Hi everybody, this is Mike Blake again, a patent attorney and trademark attorney in Milford, Connecticut. My last video I talked about the 4 different types of patent applications. Today I'd like to talk about what are the benefits of a provisional patent application. If you saw my previous videos, you may remember that a provisional patent application is like an informal patent application that lasts for 1 year. So let's talk about some of the benefits of a provisional. Generally, they're lower cost than a utility patent application. The utility patent application is the one that gets examined at the patent office. A provisional application is not examined. You just file it with the patent office and they hold it for 1 year. The provisional has a lower filing fee than a utility patent application. For a microentity, the filing fee is $60. For a non-provisional, the filing fee for a microentity is $364. Provisionals generally can be filed quicker than a non-provisional, usually because you spend less time on it. For a non-provisional application, I might spend anywhere from 20 to 30 hours or more. For a provisional, I probably spend around 5.5 to 6 hours on it. Non-provisional patent applications have a term of 20 years. So that's how long they last. A provisional application does not count against that term. So if you file a provisional, and then a year later you file a non-provisional that claims priority to that provisional, that 1 year period does not count against your 20-year term. Another benefit of a provisional is you do not have to comply with a lot of the requirements at the USPTO office. For instance, you don't have to have claims, you don't have to have set margins, line spacing. You can actually submit photographs instead of drawings. So it's like an informal patent application. Provisionals are kept secret. That's an important benefit. So for instance, if you file a provisional patent application and you end up not filing a non-provisional that claims priority, then your provisional will go abandoned and it's never published. It remains secret at the patent office. So that's important if you want some protection and then you end up changing your mind and not filing a non-provisional. Another benefit of a provisional is it gives you a 1 year delay to file the more expensive non-provisional application. For instance, some attorneys charge around $1,800 for a provisional, and that same attorney may charge $5,000 to $7,000 for a non-provisional. So if you file a provisional first, you have a 1 year delay before you have to file the non-provisional that's a lot more expensive. Another benefit of the provisional is when you file a non-provisional that claims priority back to the provisional, you can add new material to your non-provisional. Usually when you file a provisional, many inventors will improve their invention, and so they can add those improvements to the non-provisional that they file at the end of that 1 year period. And a provisional will give you patent pending status. So you can mark your product patent pending, or your marketing material, you can say patent pending with respect to that invention. And that hopefully will deter competitors from copying your invention because they know you have filed for patent protection. And they may not know that you only filed a provisional because all you have to say is patent pending. And so competitors would not necessarily know whether or not it's a provisional application or a non-provisional. I hope that helps you understand some of the benefits of provisional patent applications. Thank you.